Hello, everyone, and welcome to this weekly webinar produced by Business Performance USA. We're honored to have you as our guests. Business Performance USA is the producer of these webinars, and we offer them weekly to provide business insights on a variety of important business topics. So what is Business Performance USA? Well, it's an online business information exchange where you can meet people from across the U.S. who are engaged in business conversations on topics such as we are presenting today, background screening. And you may become a member and engage at no cost at any time. All you have to do is go to businessperformanceusa.org and just sign up as a member. And you'll be able to hear all of the webinars we have presented at a time that's most convenient for you. And today, what we're doing is offering you the webinar on the basic truths about background screening. Now, this is part 5 in a series that has been presented by Nancy Lynn Roberts. Nancy Lynn is the owner of Track One Technologies, and today standing in for her is her right arm, Vice President of Operations, Matt Graham. I'm Cynthia Stewart. I'm Managing Partner with Evermore Services. I'm your partner in building tomorrow's businesses today, and I'll be your host for this hour. So let me tell you a little bit about Matt Graham. Matt, who is a lawyer as well, so he gets to wear Esquire after his name, has over 15 years of experience in employment practices. And he joined Track One at the beginning of 2011 and helped the company to become one of only 42 companies to attain the accreditation by the National Association of Professional Background Screeners, otherwise known as NAPBS. Say that 5 times. Matt serves on the Best Practices Committee of NAPBS, and he also co-chairs the Data Breach Prevention Subcommittee. And he's one of only 40 experts, by the way, people, 40 people to be certified at the advanced level in the Fair Credit Reporting Act by NAPBS. So we're honored to have him today to talk on this very important subject that's gaining more and more traction in the marketplace, as you know. Now, if you've joined us before, you'll know that all you need to do is type in your questions in the chat box or the question feature on your dashboard. And also, you can write this down. If you have any specific questions, want to know more about Business Performance USA, just email me, Cynthia at businessperformanceusa.org. And be sure to sign up on Business Performance USA so that you can watch on demand these webinars. And with that, I'll go ahead and let Matt begin his presentation. So Matt, I'm going to change you and make you the presenter now.
Well, thank you, Cynthia. Appreciate the introduction. And inasmuch as I'm a substitute teacher today, just be known that your teacher has left her lesson plans and told me exactly what page in the book that we're on, so we'll be starting up with part 5, which is a continuation of the series. And so you should be seeing my screen momentarily, and we'll begin.
And I'll let you know. Okay, it's up. Thanks, Matt.
Excellent. So again, this is part 5 in a series, and really this is a continuation of a two-parter from the last time. We are working through kind of a checklist. As you can see, part 4 and part 5 dovetail together. So we're working on a checklist here, and the previous session addressed things such as myths about the FCRA, the Fair Credit Reporting Act, misconceptions, particularly that it only applies to credit reports. We worked through that. We talked about the end user obligations, dealing with such things as disclosure and authorization forms. Talked about tailoring the screening program, which is really taking the right types of background checks and the right type of inquiries for the right types of jobs, and what you can ask and when. And then finally on step 5, it was decision-making criteria, what basically you can and can't rely upon when making a hiring decision. So with that, we pick up on this webinar series 5 with the checklist item number 6. And so we're dealing with best practices and what you can and can't do with respect to the background check process. So the EEOC, and basically it was May of 2012, changed their criminal guidance recommendations, the enforcement criteria that their enforcement agents go out and rely upon when they're making their on-site visits. And that guidance hadn't been touched in over 20 years, so it was overdue for some updates, and some pretty major changes came out of that. All of us in the background screening industry were kind of concerned about the seemingly expansive changes that were coming into play. Things have settled down just a little bit. I think we know a little bit more. We'll talk about a couple of cases that have been filed post the release of that guidance, and how those shine some light on the subject and give us a little bit more idea about what they mean. But when they came out, the overriding criteria, if you remember about the EEOC, what they're designed to do as an agency is to remove unlawful barriers to employment. So with that in mind, you can kind of see how some of these items that came out of the guidance play into that. Really what they were looking for with the guidance is that there be no bright line test. And what we mean by that is a lot of organizations will say, we're not going to accept any convicted felons for any position within our organization. That would be a bright line test, something that's just stark and no exceptions. So that's one of the main things that coming out of the guidance that they were looking to avoid, is the bright line test. They also recommended that organizations, as you might expect, given the EEOC's focus, have regular non-discrimination training. Just regular ongoing training for your frontline managers and supervisors. Typically, it's that frontline manager and supervisor position that generally creates the most liability when it comes to employment practices, because they're often out there making employment decisions at a smaller level, but those that does tend to generate a majority of the problems that come up in the employment practices. The other item that they were looking for is to have a standardized kind of a written policy with respect to how your background check process works. A lot of organizations probably don't have that. It's one of the number of policies and procedures that often gets overlooked, just a specific policy relating only to background checks. A lot of organizations are still finding their way through that process and haven't gone so far as to create a written policy around it. But when the EEOC comes to visit, it's not what you're doing, it's what you can prove that you're doing. And without written documentation, that proof is often lacking. In continuation of the best practices recommendations, one of the things that they've wanted organizations to do was to identify the essential job requirements of the positions. We mentioned before in part one of this two-parter, creating a tailored screening program really involves examining the position as much as anything else, trying to understand what are the essential elements of that job. For example, is there any contact with the public? Is there any contact with vulnerable populations? Those are two key criteria, because the bright line test theory goes to, is that person qualified for any job within the organization? Saying no convicted felons at all rules them out from any position within the organization. So the consideration is, are there positions for which perhaps someone with a criminal record would be qualified for? So identifying the essential job requirements is a key component to making that analysis. Looking at the hiring criteria is also important, and trying to determine whether or not there are particular types of crimes that really rule a person out for a particular position. So this is kind of the same idea, but looking at it from the different direction. It's what is an acceptable offense for ruling somebody out. One of the commissioners, when the EEOC released their guidance, one of the 5 commissioners made a remark in the press release that I was kind of glad to see. It was the one sigh of relief that we all had with respect to this when it came out, was that there will be cases in which the nature of the crime is so manifestly connected to the position being sought that further inquiries or further analysis is not required. And the key example of that would come out if you don't want anybody with a convicted sex offender to be running your daycare. So common sense does prevail in this case, and that really is one of the things that you go back to when you're looking at this EEOC guidance. While the guidance itself is some 100-odd pages, honestly, common sense is really the rule of the day. And a lot of this stuff, I think, as you work your way through it and really look at the analysis, you'll find that it does make sense to not exclude a huge segment of the population that, for whatever reason, might otherwise be employable. And then again, just the identify prohibited offenses, we've talked about that. It's looking for what does truly disqualify somebody for a position. So that's kind of the EEOC best practices. There are some additional criteria that they've looked at that goes back into the some of the original criteria that was in the guidance going back 20 years back. One of those has always been, how long can you go back in somebody's history to determine whether or not a criminal conviction is a predictor of perhaps disqualification? So looking at the relevant time period, a lot of you may have either heard this or kind of this is your established practice, this 7-year theory. You can look back 7 years. That comes from two distinct sources. One of those is state law. While in the FCRA, there's really no length of time for which you can't go back, some states have adopted a 7-year theory, meaning that you can only look at criminal convictions that are 7 years or newer. That comes out of one of the studies that was done. It's a famous study. It's a Bloomstein and Nakamura study that looks at the rates of recidivism. The idea is that somebody who has committed a crime and been convicted, after that 7-year period has elapsed, is no more likely to commit a future crime than a member of the general population. So the idea is the longer away from the criminal past that you are, the less likely that person is to repeat that. And so that kind of plays into some of the analysis that the EEOC has picked back up. And we'll see when we talk about some of the cases here in the next few slides how that comes into play. But looking back and finding a criminal conviction from 20 years ago and that person has no subsequent criminal history or run-ins with the law or bad performance, you've got to wonder, is that really a reason to preclude somebody from joining your organization? And then another key part that I mentioned earlier, if it's not in paper, if it's not written down, it didn't happen, documenting the analysis. One of the things that came out of the guidance was that organizations had to show the process they went through to come up with their criteria, showing why they made certain decisions, why they decided that this crime was acceptable, this crime was not. So documenting that analysis and documenting the research that you did to play into this, the application of the guidance. So document, document, document. That's always the key with things that are coming out of the EEOC. So just keep that in mind as you go through and apply these best practices, that you have a way to prove that you've done it. Training your staff and going through and making sure that everyone is aware of these criteria and has ongoing training with respect to best practices and employment matters. That's important. The relevant criminal inquiry, that's the key that comes out of the best practices from the EEOC, is only looking at things that are relevant to the job at hand. So anybody with criminal convictions for embezzlement might not make a good CFO. Anybody with criminal convictions for assault might not make a good person to serve at your customer service department dealing with the public. Just making those common sense connections between the crime itself and the position being sought. And then it's always important to preserve the confidentiality of this information. This, like a number of other things that go into your personnel files, ought to be kept in a separate location that has limited access and should only be accessed for purposes directly related to the hiring process. So confidentiality is key. So summarizing the guidance, looking at your application and the inquiry, probably a good time at this point to mention something that's kind of a trend in our industry. We're seeing more and more states, in fact, Minnesota and Rhode Island just this January 1st became the latest 2 states to do what they call this ban the box movement. And a lot of you may be familiar with a box that's on your employment application that says, have you ever been convicted of a crime? If so, check here. That's the box that we're talking about banning. And the reason that the EEOC is kind of suggesting that you take that off your job application is they want to see that inquiry happening later in the employment process or the hiring process. So it's not something that happens on the application and is used as a pre-screening tool, but really that inquiry should be only part of a conditional job offer. So when we talk about changing your application, it's in part in consideration of that ban the box movement. Looking at your authorization and disclosure forms, we talked about those in part one. Customize your screening packages based on the functions of the position. Again, that's a direct application of the guidance. One way you can really make this clear, and it goes back into the document theory, is if you actually add to your job descriptions, which I'm sure you all have, the criminal convictions which might disqualify somebody for that position. So actually on the job description, so for customer service department, including which crimes would disqualify that person for that job. And then a couple of other items documenting your individualized assessment and decision-making criteria, whatever support matrices that you're coming up with, just having documentation behind all of that. So before I move on to the next step, I'm going to open it up to questions. I think Cynthia had one that came in from the audience.
Yes, Matt, I wanted to have you share with us what's really behind this idea of putting these guidelines out and banning the box, and why is this coming up?
Well, I mean, you can always look at we'll go beyond the initial political conversation, but really it's about the EEOC carrying out its primary function, which is the elimination of unlawful barriers to employment. Whenever we have difficult financial times and organizations maybe restrict the hiring, it becomes a more competitive environment for jobs. And those people that are seeking those jobs, any barriers to that process that are for unlawful reasons, we want to do what we can to eliminate those barriers. And when you think about it, it's really an employer's best interest to not necessarily exclude certain people from jobs just because of a criminal past. If there are clear indications that that person could be a contributing member to your organization, all the analysis needs to be done before you just make a sweeping no decision. So it's really, again, the EEOC carrying out its primary job function.
And does it, for a company, help if they ban the box? I guess what they're saying is that it opens you up to candidates that would be good candidates despite bad mistakes that they've made in their past, but that they've moved beyond.
That's correct. I mean, especially when you deal with, because typically those questions on the applications are just any criminal conviction from any time in your past. So somebody that's 35 and really gotten their life together after an early conviction at say 16, that was half a lifetime ago for them, and to immediately disqualify that person from the hiring process, you might have missed out on a really solid candidate.
Okay, very good. Thanks, Matt.
Absolutely. So one of the things that we want to do here, because I often get myself anchored into the employment process, but we provide screening services to both employers and landlords. So there's a whole section of the background screening industry that applies to people seeking apartments. And when you think about it, there's a lot of things that are going to apply there as well. Instead of barriers to employment, here we're talking about barriers to finding a place to live. So the FCRA applies to tenant screening or residential screening equally as it does to employment screening. However, the EEOC, because that's the Equal Employment Opportunity Commission, that guidance doesn't apply. But we are looking at some things that are happening in this side of the industry that could make some sweeping changes. To date, there have been 2 Supreme Court cases filed that really speak to a very broad topic Both of those cases settled before an ultimate decision was made by the Supreme Court, thus kind of denying us a chance to see what the court really thinks. But what I'm talking about is this concept of disparate impact. And I'll give you kind of a quick explanation of what that is. In the employment context, it's been pretty well established that when there is disparate treatment, whenever you are making some sort of outward manifestation of decisions on a particular category, let's just say race, whenever you're treating somebody differently because of race, that's a pretty clear violation of Title VII and a lot of other established laws. However, on the employment side, this is pretty well established when there's disparate impact, meaning you have a facially neutral policy, but you're having a discriminatory effect. That also can get organizations into trouble. And we see that with the classic case of, really it's from my law school days, Griggs versus Duke Power, where they had an entrance exam for coal shovelers at the power plant of having a high school education. Honestly, you can't really see a whole lot of connection between having a high school education and shoveling coal. Therefore, the impact of the requirement was having a negative impact on African Americans, and so that kind of was the birth of this disparate impact theory. And now what we're seeing is we're on the residential side, we're seeing some of the same attempts to apply that disparate impact theory to primarily the HUD housing regulations. And what that would mean is if a facially neutral policy that you had in place to screen your applicants for your apartments, such as credit checks, criminal record history, if those were to have a disparate impact on any protected class, then potentially that could be deemed unlawful. And so we're really watching that closely. But again, unfortunately, the settlement of those two cases that made their way up to the Supreme Court have kind of denied us an actual ruling. But we'll stay tuned on those. But now, for the moment, we're still in limbo. Now, we've talked about the employment side of things. We've talked about the tenant screening types of things. The volunteer screening is another area where we're seeing increased activity among organizations utilizing the services of background screening companies. For purposes of the Fair Credit Reporting Act, the volunteer screening that would be done out there is treated the same as an employment screening. So the same rules that we were looking at earlier with respect to the EEOC are going to apply to your volunteer positions. And that was made clear in a document that I often keep under my pillow at night. It was a document that came from the FTC talking about the 40-year history of the Fair Credit Reporting Act. And yes, it's been around for 40 years. But this document does a nice job of summarizing each section of the Fair Credit Reporting Act and then taking and consolidating all the FTC opinion letters that have happened over the 40 years and kind of putting those into one document. And that document makes it very clear from one of the opinion letters that happened about 4 years ago that employment screening and volunteer screening are one and the same. So all the stuff that we've talked about on the employment side applies. But the risk of damages are really a little bit different, and that's why we kind of treat this a little bit separately. It's not about barriers to employment or lost wages or lost opportunity for wages. Here it's more about potentially reputational damage. So you have someone that wants to volunteer and work at their church, and for whatever reason the background check comes back and there's something in the history that says no, this person's not qualified. So you worry about the reputational damage. So things that, I mean, there's still good justification, even though that there's not an employment situation at risk here. There's still a lot of reasons why an organization would want to do screening for their volunteers. Again, the safety of the organization and the people that the volunteers would be serving comes to mind initially, but also reputational damage for the institution that the volunteers would be representing is an important consideration. So there's a lot of reasons why, even though they're not applying for a paid position, that you would still want to consider some sort of evaluation of their background. And we'll look at some of the other factors that come into play a few slides here later. So we're looking at checklist item number 7 now. So your organization, you know that your staff is being trained. You've got policies and procedures in place. You understand the adverse action process. So that's what we're going to be looking at now. Is really what do we mean by adverse action? And this is a really important section. And you'll see in a minute that we talk about the Walt Disney Company is currently facing a potentially class action lawsuit for failure to abide by these adverse action process and regulations under the FCRA. So we'll walk you through this and let you see firsthand how simple this is and really why this shouldn't be something that trips up organizations as much as it does. So first of all, I guess what we need to do is kind of define what an adverse action is. Adverse action really means anything that would be a negative consequence as the result of looking at a background check. And so that could be a failure to hire that individual, failure to promote or retain, anything that would have a negative impact on that person, salary evaluations, and including up to termination. So that's what we mean by adverse action. Now, the employment application of adverse action is a little bit different than the residential adverse action. There's an extra step that is added to the adverse action process in the employment context. So the extra step is this concept of a pre-adverse action notice. So actually, before you make the final decision not to hire an individual, if that is indeed the adverse action, then you have to provide a notice of that potential adverse action. And that notice, you also need to include a copy of the background check, or as we call it, consumer report. And you also have to provide a copy of a document that the FTC, now the CFPB, the Consumer Financial Protection Bureau, has created. It's called a Summary of Your Rights under the Fair Credit Reporting Act. So a copy of the report and a copy of this particular document needs to be given before that decision becomes final. Why that's important is that if you understand what the FCRA is, it's a consumer protection statute. It's designed to give consumers an opportunity to correct the information that may be false or inaccurate within a background check or consumer report. So there's this concept of pre and post. So how pre does it need to be? How much time do you need to give somebody to look at the background check, say either that record doesn't belong to me or that record is incorrect? Well, we don't know. The FCRA actually doesn't go so far as to define that period. However, looking back to the guidance that we get from the FTC opinion letters, that process should be at least 5 days. Really more than the number of days. What we're looking at here is, does the applicant have a meaningful opportunity to respond to the information that comes up in the background check? And so that's what you're looking at. If your applicant is able to get back to you same day and say, whoa, that's not me, or no, my record's been expunged, and it can provide you documentation of it, and that happens in 2 days, great, you can move on to the next process. But it's really allowing the consumer the opportunity for a meaningful response. So once you have that process, once you've waited those 5 days or however long you need to allow to correct any kind of information, if no response is forthcoming, or the response is, yeah, that's me, I did it, then you have a decision to make. Is the information contained in that background check going to make you not hire that person? If so, then you have an obligation to provide them the post-adverse action notice. And this is the one piece that survives if you're talking about the residential screening or the tenant screening. So in tenant screening, all you have to do is, once the decision is final, provide this information. And there's some very specific things that are required in this. Most of your consumer reporting agencies, when they provide services, will either offer you the option of handling this process on your behalf and sending these letters out, and will either provide you model notices, but there are some specific things that have to be included, and those are listed here for you. The name and the address of the consumer reporting agency that provided the report. There's an important thing that really helps us out, is a statement that the CRA, the Consumer Reporting Agency, didn't make the decision and doesn't know why the specific reasons for the decision were. And then finally, just a notice that the consumer has the right to dispute anything and request a free copy of the report within 60 days. So most of this is kind of a form letter type thing, very easy process. But again, it's just remembering that if you are going to be using consumer reports in your hiring process, then you as the end user, the employer or landlord, have obligations to provide the consumer, the subject of these reports, with some information if negative actions are going to be taken. Any questions about the post-adverse action, Cynthia? Anything coming in on this one?
I guess one of the questions is, you kind of mentioned that this really refers specifically to employment. So in the case of tenancy or, leasing or things like that, should they be aware of this as well? I mean,
Absolutely, yeah.
yeah.
And
Okay.
just the post adverse action. So
Right.
the
Okay.
concept of the pre and post only applies to employment, but even if you are looking at consumer reports, and most landlords do, and specifically in those instances, they're looking at credit, and we'll talk in a minute about why credit is kind of frowned upon in the employment context. But yes, landlords need to be aware of this process, and they need to be providing these notices whenever a decision not to rent to that applicant is made.
And are we assuming that for volunteers as well?
It does. The volunteers is a little bit tricky. It's in terms of giving best practices advice, I've got to say that you've got to do this even for your volunteers, because again, the FTC has said volunteer screening is just like employment screening. So the pre and post apply, but at that point, some people are saying, well, the EEOC really probably isn't going to be looking over my shoulders in my soccer club or my church. And that's true. They're primarily going to be looking out to enforce true paid staff type positions. But it is the letter of the law. It is the spirit of the law. And honestly, there's no reason why you wouldn't want to communicate with members of your organization about things that come up in a background check.
So best to be consistent in your practices is bottom line on this.
Consistency is always a good thing. And one important thing to remember about background screening is that may just be one criteria in your hiring matrix. I'm sure you're looking at qualifications and other things that stand out. And so the thing to remember about background screening is, even if it plays a small part in your hiring process, if you are relying upon anything that comes back in that background check, this adverse action process is triggered. And honestly, it's really hard to say that once you've looked at the background check and negative information shows up, that it didn't play into your decision. So it's a good process to follow, even if the background check was a very small piece.
Okay, thanks for that.
Finally, we're going to talk about a little bit of things to look for when you are engaging a consumer reporting agency to do the screening on your behalf, and that's checklist item number 8. So we've told you mostly up to this point about end user obligations that fall on your shoulders, and now we'll look at some of the things that impact consumer reporting agencies like ourselves. And so it's important to remember, just like a lot of other service providers out there, that not all companies are created equal in this respect. Fortunately, there are some ways that you can easily identify and separate the wheat from the chaff. And one of those things is participation in industry association, the National Association of Professional Background Screeners, as Cynthia mentioned earlier in the introduction. There are about 750 members in that association, and that includes full-blown CRAs and other associate members as well. But truth be told, there are probably unknown thousands of organizations out there that are really providing background check services and really aren't even on the radar. So it's kind of hard to know how many organizations are actually out there. But one thing is true regardless of participation in NAPBS, there really is no one single source for all these criminal records. Even the federal government doesn't even have a complete database of all criminal records. The FBI database is great for what it is, but it mainly contains only arrest records and tends to lack final dispositions in all the cases, meaning that subsequent judicial process may have occurred since the record went into the database, and whatever comes into that is not always kept up to date. So now, perhaps some things have changed. Edward Snowden and the NSA may indeed have a complete database of all criminal records. They may have a complete database of all activity in the United States, as it seems. But for the moment, for consumer reporting agencies, what we generally have access to and what can be brought into a criminal report, the resources are many and partial. So it's a matter of being able to get all the information compiled from different locations. So no one single source. And we talked about the membership. There are some other organizations, the National Credit Reporting Agency or Association, that deals primarily, the NCRA deals primarily with the screening side on residential or tenant screening. There are other associations, but really the NAPBS is kind of the flagship organization for our industry. So look for membership in that. They've also, as we mentioned earlier, there's a accreditation program that was established about 2.5 years ago. To date, only 42 organizations have gone through that process. Even if you assume the 750 number, 42 out of that I think gives you about a 5.6% accredited rating. But again, I think there's probably untold thousands of organizations that are out there that are holding themselves out as a background check company. And that kind of plays into a couple other points here. The barriers to entry in our industry have never been lower. You can buy a platform, a background check platform. You can buy your data and basically be nothing more than a sales and service office and kind of can call yourself a consumer reporting agency. So control matters, and having access and control to your own database and your own platform is an important distinction, I think, and something to consider when you're looking for consumer reporting agencies to represent your organization. We talked about the importance of the accreditation and the certification. Everyone at our company that comes into contact with consumer reports or is involved in any way in producing those reports is certified in their understanding of the Fair Credit Reporting Act. So when you're looking for providers, make sure that they know what they're talking about, because it is a complex and highly regulated industry, and you need to make sure that someone is looking out for your best interests. Information in terms of what's available out there, a lot of people will go for that instant database because they like that instant gratification and knowing whether or not their applicant's clear. But know that the faster you get your report, the less likely it is to be complete. And if the databases, one of the challenges in our industry right now is accuracy. And these databases may be archived sources. They may not be up to date. And so while you may be looking at a criminal record for somebody, that record that may have been dismissed, may have been expunged, your reliance upon that needs to be the faith in the record that you're looking at needs to be well placed. And so organizations, consumer reporting agencies that verify their hits, the criminal information before they report them, that's an important thing to look for also. Service is another important consideration. We've seen a lot of organizations in a lot of different industries attempt to offshore their customer service, their call centers, and wherever your feelings may be on that subject, sometimes the quality does suffer. And knowing that the United States criminal justice system is one of the most complex, one of the best, but one of the most complex out there. Do you really want somebody in another country trying to explain to you what a criminal record means? So looking for organizations that have made efforts not to offshore their service operations, their fulfillment operations, that's an important consideration as well. And that does also play into some of the security matters. Different countries have different regulations regarding the security and safety of online information. You've seen here recently how the Target breach has created some pain and suffering for a lot of individuals that are dealing with identity theft as a result. Think about where your information is going whenever you offshore your criminal research. That should be a consideration. The other thing too is just the reliability and the safety of the information, and the ability for an organization to recover from, say, a data breach or even a data failure. Just knowing what your consumer reporting agency provider has in the way of data backups, and can their information be recovered if some sort of outage occurs. And then finally, just understanding whether or not they have a firm grasp on the compliance issues. A lot of your consumer reporting agencies will provide compliance services or compliance bulletins, newsletters that tell you what laws are changing. That's one of the things I'm kind of proud of here, is that we've got a really good set of compliance resources that we make available to our clients, because it's important. While it's important to us and exciting to us, background screening isn't everybody's cup of tea, and keeping up with that information isn't always top of mind for everybody. So we do that for you.
So, Matt,
Uh,
question.
sure, absolutely.
Can you sort of frame for us the risks that companies take on when they use, say, one of those instant background screener shops? Frame the risk for us when they're using someone that really doesn't have a good database, or doesn't have good practices, or isn't certified.
Absolutely, yeah, and it's important because I mean, beyond just the certification itself, it's what that actually means. The companies that provide the $5, the $8 searches that really just look at a database of records have two main problems. One is the completeness of that resource. As we mentioned earlier, there is no one single database that contains all criminal records. So what you really need to understand is the coverage areas, and not just a lot of companies will tout the number of records they have in their database. It really has less to do with the number of total records than it does with the coverage areas. You want to ask what resources are compiled in their databases, and if they can't tell you, that's a good warning sign. The challenge is some states are more freely giving of their data to these aggregators than others. So some states, you may have limited coverage in these proprietary databases. North Dakota is a common example. Very little of their information is available to purchase in bulk. and therefore you actually have to go to the criminal courthouses in the state to get the information. So if you're dealing with just a company that provides online databases and instant records, you're likely going to be missing out on those records that are only available from courthouses. And believe it or not, there are still quite a few jurisdictions where you actually have to physically walk up to the courthouse and pull records from a clerk. It's not as instant and online and as technology laden as the TV and movies make it out to be. So the risks really to you is that you are going to miss information that might otherwise disqualify an applicant. And if it turns out later on that somebody either assaults somebody within your workplace and that their criminal record is easily found at the local courthouse and all you did was the cheap database search, that's not going to play out well in the news. That's not going to play out well in the jury box, and that there's your exposure there. So looking at some of the risks that apply to consumer reporting agencies in our industry, while the users of our product have the EEOC looking over their shoulders, we have primarily the FTC looking over ours. And we have certain obligations as consumer reporting agencies that we have to follow. Consumer dispute process is probably one of the most important because information even in the courthouse records is sometimes out of date or inaccurate. There are times when a consumer will have to dispute something that comes up in a report. And that process has to always be in favor of the consumer and kind of give them the opportunity to correct the information. And so we have a really robust dispute process here. It is mandated by the Fair Credit Reporting Act. So we work with our consumers very closely whenever information comes up. And I'm happy to report that our dispute percentage based on the number of reports that we produce each year is actually under 1/20%. Very low. So that would be something else to ask of a consumer reporting agency when you're looking to hire one, is what is their dispute rate? That'll give you an indication of how accurate their reports are out of the box. 613 consumer notice compliance, that's kind of complex, but it's really pretty simple. 613 actually refers to the section within the Fair Credit Reporting Act. There are really two options that consumer reporting agencies have whenever they produce a consumer report. They can either make sure that the records that they are reporting are the most current and up-to-date by verifying those records with the original reporting jurisdiction. So that kind of rules out the instant database. You have to go back and anything that comes up, you have to verify with the courthouses. Or you can send out a notice, a letter notice that goes out to the consumer, the subject of the report, that a public record report has been made and that there could be information in there that they need to verify. A lot of your consumer reporting agencies that don't really want to deal with the accuracy issues will opt for that notice concept. But the more enlightened consumer reporting agencies will follow that verification of hits. So again, that's another thing to look for when you're looking for CRAs is whether or not they verify the hits. The overriding thing that kind of follows our industry is this concept of accuracy. That's really what the Fair Credit Reporting Act seeks to do within our industry, is assure that companies like ours have reasonable procedures to assure maximum possible accuracy. So that's one thing that you can do when you're looking for CRAs, is ask what their procedures are. How do they make sure that their reports are accurate? So we've seen quite a few lawsuits happen here recently, both against consumer reporting agencies and against end users that utilize those services. We'll talk about a few of those. I also just want to point out too that the FCRA allows for punitive damages, court costs, reasonable legal fees, and there are statutory damages up to $1,000 per violation. So you can see how sometimes these would turn into class action lawsuits, especially with organizations that do a lot of hiring. One of the ones I want to mention right off the bat is the Disney case, because it was just filed in November of last year. Again, they weren't following allegedly the adverse action process, and because that is such an easy thing to do, it seems silly that an organization of their size would be, kind of falling down on the job on that. But that has yet to kind of play itself out in the courts, and we'll probably know more facts later. But just understand that that's, again, potentially $1,000 per violation of each person that was not notified of the adverse action as they should have been. Other standouts here, I don't really have time to mention them all, but two cases that came out of the EEOC enforcement criminal guidance were the Dollar General and the BMW case. This kind of helps shed some light on what they were thinking when they changed their guidance. In the case of Dollar General, there was an applicant who self-disclosed at the hiring process that she had a drug conviction from 6 years ago. And that, so the employer knew that that was going to be something that came up. She also had a good employment history post-conviction with another large retailer. And so Dollar General, kind of in the same line of business. So this person had other kind of remediating factors involved, and Dollar General decided not to hire this person based on that criminal conviction. They weren't going to hire her for a cashier position. So the EEOC looked at that and said, this is one of the things that we talked about. This employee had good employment history post their conviction. Drugs, cashier, we don't really see the connection. So we think that's an unlawful barrier to employment. With the BMW case, what we saw was it was really kind of an interesting situation, because there was a transition of contractors. Such that this contractor basically was going to fire all their employees and then immediately rehire them back. Something to do with the contract with the manufacturer. It was really kind of an interesting situation. But what happened is, when they went to do the rehire process, they had subsequently adopted a criminal record process whereby they were doing background checks, and they had some employees, some 14-year tenured employees, that were disqualified because of prior convictions. And again, the EEOC stepped in and says, no, wait a second, that's exactly what we're talking about. This person's been working in your exact facility for 14 years with no problems. Why is that conviction now suddenly a disqualification for employment? So these cases are still working their way through the courts. We don't have much more information on them. Certainly will be interesting to see how they play out. More than likely, they will go the way that most of these do. Against the EEOC, there will be some sort of settlement. But usually out of those settlements, there's some non-monetary benefits that are afforded the class members. And usually what that means is the EEOC will mandate new procedures that the employer adopt. And generally that will show you as another employer what you should do before the EEOC mandates you that you do it. Cases against my industry participants. There have been several. A couple of those have been fairly recent. I won't go so far as to call too many people out, but we've already kind of done that in print form. But but for the grace of God go I, sometimes we like to say, and there are some things in here that were fairly egregious in some of these cases. So I don't mind pointing those out. First one really is the top one there on the list. ChoicePoint in 2006 had a breach of sorts. It wasn't like a technology breach, but a client of theirs, somebody that was having access to credit reports, managed to kind of infiltrate the process. They had really no legitimate case for accessing the information. As it turns out, they were a member of the criminal element. They were running thousands of credit reports out of an apartment, basically for identity theft. So this choice point case really kind of came for the credit bureau as kind of a wake-up call, in that they really want to investigate who has access to the information and making sure that they have a legitimate purpose. So now most of our clients that we bring on board, we have to do an on-site visit and make sure they're a legitimate business, not some guy running things out of an apartment. So that really kind of set off quite a few things. One of those was actually the breach laws that Target is now dealing with. Companies having to notify people in case of a data breach. That was really kind of a consequence as a result of that choice point case. A couple other recent ones, the Higher Right case and the IntelliCorp case, those were very recent. And really it's just not paying attention to details, not having good consumer dispute processes, and not managing the accuracy of the reports. So all those companies are facing revising their policies. IntelliCorp, in fact, is now required to verify all hits before they make their report. So some companies have opted for that as part of their processes. This one has now been mandated by the FTC to do so. And it's not just limited to employment-related screeners. The ones you see on the bottom where the warning letters were sent out to the tenant screeners, those companies were trying to operate kind of under the radar. They use disclaimers everywhere saying that they were not consumer reporting agencies and don't use this information. But then they would kind of advertise and kind of say that, use our information for this purpose. And really all those that you see listed, it's not clear that they have violated any laws, but when the FTC sends you a warning letter saying that you may want to review your practices, pretty good idea to do that. Same thing with the Spokio case up above. They were trying to disclaim any application of the Fair Credit Reporting Act. They tried to say, we're not a consumer reporting agency, don't use this for employment purposes, but then they would advertise to HR people. So again, it's really FCRA compliance is something that you don't want to trifle with, and these organizations all found that out the hard way. And then finally, kind of to wrap things up, we do want to make you aware of state law considerations. Everything that we've been talking about to date has really been at the national level, really looking at the Fair Credit Reporting Act, but all the states you see listed here have done something that kind of expands or kind of creates a little bit of a variance to the FCRA. And the ones that you see in red are states that have done something to limit the access of credit reports. So in the employment context, and as I alluded to earlier, although tenant screeners tend to look at the credit first, a lot of states have said credit is really not relevant to the employment context unless that job has something to do with fiduciary responsibility or some sort of financial access. So to eliminate additional barriers to employment, because a lot of people have credit problems given the recent financial crisis. They've enacted laws that kind of limit your access to credit reports in the employment context. So, and I guess with that, we'll kind of wrap it up here with some takeaway points, and I'll kick it back over to you, Cynthia. With employment screening, again, it's making sure that you've considered everything that the EEOC has done with their revised guidance, making sure that you are contracting with a consumer reporting agency that really knows what they're doing and providing you with accurate information, and making sure that you are following the pre and post adverse action process. And prior to that, also making sure that you have disclosure and authorization forms that are up to snuff. And then maybe going beyond the criminal records. I mean, that's kind of what we tend to focus on, but there's still some value to looking at references, personal references, professional references, other things that might give you more of a story than just a criminal record history. And then maybe a probationary period, giving somebody 30, 60, 90 days to prove themselves, maybe in light of a criminal record, and taking a chance on that individual, but letting them know that their employment is conditional. And then finally, the volunteer screening practices really aren't that much different than the employment. Where areas where it does kind of tend to deviate is just making sure that you're looking out for the risks involved. In this case, it's probably risk of defamation, anything that might come up in terms of a report that might make that person look bad if it's not verified. Knowing that you have to do the pre and post adverse action process. And then most volunteer organizations, because they are limited in financial means, they tend to do just the basic search, just looking at sex offender registries, but there are a lot of charges that could disqualify somebody from working with a vulnerable population that don't amount to a sex offender registry qualifying crime. So well, I appreciate your opportunity or appreciate the opportunity to present to you today. And if there are any questions, we'll try to wrap that up as quickly as possible.
Matt, go ahead and take us to the
Cynthia?
last slide. Go ahead and take
Okay,
us to the
great.
last slide. Okay.
Should be coming up.
Yeah, and next month at the fourth Wednesday is when background screening will be back, and more wonderful tips, practical tips on how to make sure that you're covering your company, and also as a consumer, understanding the laws and how they affect you as well. So join us next month. In fact, next week we'll pick up with our next presenter on social media. Uh, and we ask you to come be a member and participate with us on businessperformanceusa.org. Remember, it's free to join, and you can see all of these wonderful webinars with these great business topics and do it in your own time on demand. If you have questions regarding background screening, write this down. You can always contact Nancy Roberts directly, and she is the owner and COO of Track One. And the number you can call to get information is 1 800 600 8999. You can also look at their website and gain information there as well. We thank all of you for your time and attention today, and we look forward to hosting you back next week. Thanks so much, Matt. You did a great job. We appreciate all the information you're sharing. So, bye, folks. See you next week.